Content in this podcast is not legal, financial, or investment advice.
And so what fashion brands and other brands need to do is they need to think about, and this is what this person said, they need to become technology companies that sell fashion, not fashion companies that use technology. And that's vital because in this age of the metaverse and virtual goods and virtual fashion and NFTs and crypto, there's a level of tech savviness that you have to have as a company. And it's important for the day-to-day execution of your business, but it's also important for growth, corporate growth, because there are all these opportunities for new ways of generating money within fashion companies.
Hi, I'm Mike D'Annunzio, the founder of Pebble Ventures, and I'm with my colleague, Lauren Fenema. So Lauren, that was a great conversation with Gina. She had so many interesting things to offer for brands thinking about getting into the metaverse and those that are already there.
Yeah, totally agree. I especially loved covering her perspective on what's going on with trademark, especially some of the cases we've been following around Hermes and how that's all going to work out with the mini Birkin bags. Super interesting to see how that translates in the metaverse and what that will mean for the future as far as setting precedents, and also getting her perspective on the Nike StockX. I know there's a lot of folks in the industry really eager to understand how that's going to play out. So it was really cool to have her come in with such, concise and helpful perspective, obviously not legal advice, but great deep dive into each one of those issues, along with just her general thoughts on how to kind of prep and explore this space while, taking the steps to think through the legal implications of things.
Yeah, totally. All right. So let's jump into it.
Sounds good.
Welcome everybody to another episode of Metaverse Matters. I'm Mike D'Annunzio, the founder of Pebble Ventures, and I'm here as always with my colleague, Lauren Fenema. And today we're really happy to have Gina Bibby. She is a partner and head of the global fashion tech practice at Withers Worldwide. And while none of this is legal advice, we are here to talk about a lot of issues that brands are starting to think about as it relates to their entrees into the metaverse. So Gina, welcome and thank you so much for taking some time today.
Thank you so much for having me, Mike. It's a pleasure to be here.
Great. Well, if you wouldn't mind, maybe just open up and just give our readers a little bit about your background and your practice, and then we'll kind of dive into some of the things you've been quoted quite a bit from Bloomberg to Vogue Business. So we want to kind of jump into that, but just a little bit on your background would be great.
Sure. So I like to say that I come to my fashion tech practice by way of an honest journey. In my former life, I was a computer software engineer. In fact, I practiced in industry as an engineer for 10 years, and my undergraduate training is in mathematics and computer science. And once I graduated law school, I spent the bulk of my career to date practicing in Silicon Valley on complex IP matters for high-tech companies, the who's who list of high-tech companies. And while I was practicing in Silicon Valley, in the back of my head, I had always had a thought that I wanted to start my own practice with bringing in my IP knowledge and my love of fashion. And the interesting thing is I caught wind of a collaboration between Levi Strauss and Google. And I thought to myself, now these are very strange bedfellows. And so there must be some there. And I suspected that this idea I had been ruminating over with respect to a specialized fashion practice that had an IP focus might have some relevance once I figured out what the Google and Levi Strauss collaboration was all about. So when that collaboration, which is called Project Descartes, was pushed to the public domain, I learned that Google was helping Levi Strauss to create conductive fabrics and yarns that could be woven into various garments. Specifically for Project Jacquard purposes, the garment was what Levi called a commuter jacket, where you could, a touch technology was woven into the yarn so that you could just run your hand across the sleeve or some other portion of the garment and operate your phone and other electronic devices. And I thought to myself, now this is really interesting. I don't know of anyone who's advising clients, not in a one-off way, but in a specialized way at the intersection of fashion and technology. And so I started out on my journey to build a fashion tech practice that was specialized, and ended up eventually here at Withers Bergman, which is what the firm is known as in the United States, and Withers worldwide outside of the United States. And I started the firm's fashion tech practice, and I'm as you mentioned, Mike, the global head of that practice.
Wonderful. Well, that's such a cool journey. I remember when Levi's came out with that, with the collaboration with Google. It really was one of the true innovations, and just opened up the aperture for so many people to start to think about new ways to make clothes, wear clothes, have clothes, do things that they don't normally do. So very cool. Well, maybe we'll just jump right into it. You were recently quoted in Vogue Business about how to trademark the metaverse. And it would be really helpful if you could maybe guide some of the clients, and just some of the things that you're saying are, hey, these are the top issues that you should be thinking about as you start to enter into the metaverse, whether that's as simple as augmented reality or gaming that we're very familiar with, all the way to virtual world. So do you have a set of kind of top items that, you know, brands and corporations should be thinking about?
So if I were to address trademark protection specifically,
Sure.
there were questions initially about whether or not brands and other companies really needed to file for trademark protection for the metaverse. And I think the general consensus was, at least in the legal community, that it was likely true that if you had a real physical world trademark, that trademark would translate into the metaverse, but that to cover your bases, it would be a good idea for brands to also seek trademark protection for their virtual goods and their virtual logos and things of that sort. And so that's the advice that I give clients. While it may be the case that your physical trademarks will translate into the metaverse, it's a smart move to also seek trademark protection for the virtual world. And that advice actually has borne out in the, to be true in the Hermes versus Rothschild case.
Right.
Because there in the court's last order, effectively the court said that the trademarks owned by Hermes do apply in the metaverse with respect to NFTs. The question there is whether or not the artist who minted the mini Birkin bags has defenses against trademark infringement on physical world trademarks by way of the First Amendment. Okay. So I don't know if you want me to get into a deeper dive about the legal issues there. We can save it for later, or I can talk about it now.
I thought that was pretty interesting, actually, just reading through part of what you were quoted on with the cultural reference versus what is art, what is trademark. And I think that might be where that goes. And if that's true, I'd love to hear a little bit more. Otherwise, you know,
Sure.
Yeah.
Yeah, so under the Rogers case, what that case says is that while there are trademark owner rights, those trademark owner rights have limits. And where that limit is if the trademark is being used in an artistic, expressive context. And so that's where the rubber meets the road in the Rothschild Hermes case. The judge in that case and a jury, if there is one, will have to decide whether or not the mini Birkins are a pure artistic expression that are not source identifying, that are not meant for your typical commercial purposes that you have when you're dealing with trademark owners' rights. So it will be really interesting to see how the judge comes out in this case, what he decides, and whatever he decides will be very instructive as to how the IP laws are going to apply in the metaverse. We know they're going to apply, but we don't know exactly how. So there are some open questions there.
Interesting. When do you know when that's going to be decided? Is there a timeline on that?
I have not looked at the scheduling order. The Rothschild artist submitted filed a motion to dismiss with the court, which is resulted in the order that I just mentioned from the court. So I'm not sure what the timeline is for that, although I suspect that the judge in this case is not going to delay matters, just because there are so many people at the edges of their seats waiting to see what the legal precedent will be in this case.
Interesting, very interesting. Is that, and then I also saw you were quoted about a Miramax Quentin Tarantino issue, which I also think is really interesting, because if you take historical or brands, they've got a lot of assets that they've had for many, many years. And then, some people may want to do something with those assets, whether it's a celebrity or not, where the brand may want to do some. Is that another case that you think is going to really provide good insight and guidance to the industry?
Actually, I don't. And I'll tell you why I
Okay.
don't. Because based on the facts of the Quentin Tarantino case, it's more of a contract interpretation question and less of a how do the IP laws apply in the metaverse.
Okay.
So I think the decision in that case will be less instructive for brands going forward as they operate in the metaverse than will the Hermes, Rothschild, and StockX Nike cases.
I was going to ask about that StockX Nike case and whether I feel like for me as a consumer, and even just in this world of, being alongside Pebble Ventures to explore this on behalf of our clients, it feels different than the Hermes case. The Nike kind of going against StockX and what they're doing from an NFT standpoint. Do you feel like that case is different, or is it kind of in the same bucket of considerations when we look at Nike versus StockX?
So there are differences and there are likenesses. The likenesses exist in that the courts are assessing what IP owners' rights exist in the metaverse. So in that regard, they're the same. The legal questions, however, I see as different. So in the Hermes Rothschild case, you're dealing with an artistic expression which implicates freedom of speech constitutionalities, right? First Amendment issues. That would be the defense in that case to trademark infringement. Whereas in the Nike StockX case, you're not dealing with an artistic expression. You're dealing with an NFT that StockX alleges tracks ownership of a physical item, Nike shoe, by way of example. And so the legal question there is going to be slightly different. And that legal question will be whether or not StockX has defenses against trademark infringement based on fair use. And StockX is going to argue, and has argued in his papers, that we fall into the fair use exception because we're not using the Nike trademark as a source identifier. We're merely using it to track ownership of a physical world item. And so therefore, the trademark infringement is not relevant here.
It's so interesting because I think and extend this to all the huge trend around resale, obviously. And when I think about, a Real World or even any of these other sites thinking about how to enter the metaverse and NFTs, running into that kind of similar issue of being able to resell really great products and, you know, be thinking through some of those considerations. And if they were to launch NFTs to help understand that ownership, this is an interesting case to apply and understand. So that's one of the things that I've been curious about, is how some of these copyright issues are going to affect resale and ownership as we extend into this, you know, next phase of fashion.
Right, both copyright and trademark issues. And I think if you step back for a moment and you look at these two cases, there are some very instructive, from a practical standpoint, lessons to be learned for brands and other companies. On the one hand, what these cases tell you is that if you're going to be minting NFTs and you're involving the IP rights of others, you have to be very careful, consult with legal counsel around whether or not your use will constitute infringement. On the flip side of that, for brands who are bringing these lawsuits, they have to do their diligence as well and figure out whether or not bringing a lawsuit is the right thing to do in light of the contours of the law. You know, will the law support a trademark infringement claim? Will the law support a copyright infringement claim? And does it make sense to bring these lawsuits in light of those contours of the law? So it's double-sided.
Yeah, that's great reflection. I was curious if we could get your comments on, you know, thinking about the Bored Ape Yacht Club and some of these emerging brands in this space, and how they're approaching just from the get-go that you can have commercial use and kind of have different ways of applying their IP through, you know, through licensing and things like that. Are those different? Are they probably relying on the similar laws that exist today? Or are they helping invent and reimagine some of the ways that trademark is going to be used in the metaverse, for example?
Well, I mean, all that they have to rely on are the existing laws. I'm not familiar specifically with what they're doing, but I can confidently say that whatever the existing trademarks and copyrights and other IP laws that are on the books, they will be relevant.
Great.
And Gina, do you get involved much in helping brands with development of smart contracts, and kind of how do you think about smart contracts relative to, you know, kind of other typical real world, I'll call them, contracts that you're used to working on?
Sure. So we have a global crypto practice here at Withers. And as part of that crypto practice, we get involved in smart contract development and what have you. And just like we've discussed with the IP laws and the metaverse, you know, there are some counseling we have to do around smart contracts because you have to take into account enforceability considerations.
Okay.
Generally speaking, just to give you a little contract law primer. So what you learn in law school is that in order to have an enforceable and valid contract, you have to have an offer, an acceptance of the offer, and consideration. There has to be value associated with the contract. And as long as you have those three things, you have a valid and enforceable contract, whether or not the contract is oral or it's written, with some exceptions. So under the Uniform Commercial Code, sales of goods over $500 must be in writing. So an oral contract will not suffice. And then under the statute of frauds laws, both federal and state, there are certain contracts that also must be in writing. And those contracts are sale of goods over $500, marriage contracts, guarantor contracts, when you're guaranteeing to deal with the debt of a third party. Another example would be performance contracts, where the performance extends for greater than a year. There's one other I'm forgetting at the moment, but those types of contracts have to be in writing as well. So the question that you have to ask is, would a smart contract not violate the UCC or statute of frauds, the federal or state statute of frauds laws? And so generally speaking, because of the Uniform Electronic Transactions Act and the Electronic Signature and Records Act, electronic contracts and electronic signatures in those contracts are generally recognized. Now, the caveat is that contract law is governed by the states. So you have to make sure that you consult your state contract laws to make sure that there are no exceptions. In other words, that you maybe a smart contract would not be valid under certain circumstances under a state's statute of frauds law. So you have to be diligent about making sure that the subject matter of the contract is one that is fit for a smart contract and would be valid and enforceable. There are some other issues with respect to smart contracts that I think that brands and other companies need to think about. Because a smart contract is effectively code that's written to execute on the blockchain. In the physical world, when you have a written, typed, or whatever contract, both parties on either side of the agreement can see the physical contract. They know what the terms are. They can consult with their lawyers about the terms. They sign based on those terms. But now we're in the world of the metaverse and a smart contract, and you're talking about code. So what can you do to ensure that you understand the terms of the code? And so what that may mean is that you have to engage technical experts to interpret the code for you or to review the code to assure you that the terms are what you expect them to be. So that's one consideration. Another consideration is sometimes smart contracts, you have to rely on what they call off-chain resources. So if to execute the contract, you need to get some information that is outside of the blockchain. You have to go to third-party resources off the blockchain to get that information pushed onto the blockchain so that you can execute the contract. So what that means is it's an extra layer of complexity, and brands and companies need to be thinking about that. The other thing that I think brands need to pay attention to with respect to smart contracts and the advice that we give, when you're in a business to business context, one business is on one side of the agreement, the contract, another business is on the other side. There's a certain level of sophistication and resources that are assumed. You have legal resources on both sides. You have technical expert resources that can read the code for the smart contract on both sides, generally speaking. But what happens when you're in a B2C or a business to consumer context? Well, the consumer probably likely does not have the resources that I've just listed, and likely may not have the sophistication in dealing with a smart contract. So you have to be very careful in that context, especially because what a consumer can say is, I agree to these terms, but I can't confirm that the terms are actually coded into the smart contract, right?
Interesting.
Another consideration that we advise on when dealing with smart contracts is smart contracts are self-executing, as you know.
Right.
And what that means is that there's not a lot of human intervention involved, unless you're dealing with an off-chain resource through an Oracle or something like that. And so amending and revising contracts has an extra layer of difficulty. And if you don't build in the constructs from the very beginning in the code to deal with scenarios where you're amending the contract or rescinding the contract or all of that, it's a problem because that contract is going to self-execute. So that's the type of legal advice that we give in addition to other things around smart contracts.
I can't imagine, did you ever imagine that your engineering start would come full circle now where you're pairing law and code and an understanding? I mean, you have such deeper understanding of these things, how they work because of your background.
Yeah, well, I have to be honest, when I decided I would do something other than engineering and software, I made a conscious effort to choose a career where I could exploit all of that knowledge and education. And frankly, that's the choice I made when I decided to go to law school, and I decided to practice in the IP space and tech and become a registered patent attorney. And it was also my consideration when I started my fashion tech practice, because I knew, as I said earlier, I was coming to this practice honestly. Like, I understand fully the technical side of things, and I understand fully the legal side of things, which would not be the case for your average lawyer. I mean,
Right.
we're never average, but
Right.
you know what I'm saying.
That's great. What are there any emerging issues that you're starting to see that brands maybe need to be thinking about that are coming up as a result of all this innovation that's, starting to happen now?
So I will take you back in time to several years ago when I was thinking about what was happening at the intersection of fashion and technology. And I was at an event in New York City, and someone said something that at that event that really stuck with me. It was a conference, and I can't even remember who said it, but it was so profound that I wrote it down in my notebook. And this person said the following, that companies, fashion companies and the like, who do not become tech savvy are going to get lost. They'll get, pushed into the background of the economy, right? And so what fashion brands and other brands need to do is they need to think about, and this is what this person said, they need to become technology companies that sell fashion, not fashion companies that use technology. And that's vital, because in this age of the metaverse and virtual goods and virtual fashion and NFTs and crypto, there's a level of tech savviness that you have to have as a company. And it's important for the day-to-day execution of your business, but it's also important for growth, corporate growth, because there are all these opportunities for new ways of generating money within fashion companies. And for example, companies like Louis Vuitton and Chanel and Balenciaga and all of those companies need to start thinking about the metaverse and what we're going to do in the metaverse. And you do it and make money for your company before somebody else does. So the perfect example is in the gaming industry, right? It's a multi-billion-dollar industry with lots of opportunity. And although I'm not a gamer, I do know that in the gaming context, people have things called skins. And who doesn't want the most trendy skin or the best skin? So if I were in the gaming world, I can tell you for sure, I might want to have like a Gucci jacket in that
For sure.
in that gaming context.
Me too.
Exactly. And so brands need to think about this. It's going to be an opportunity cost if they don't branch out into the metaverse and start minting digital collectibles and the like. for themselves.
I think that's so spot on. Lauren, I know you've got a question. Fire away.
Oh no, I'm just agreeing that if I were a gamer, I also would want a Gucci jacket. And I think what we're seeing too is a lot of brands extending into these gaming spaces. And I think it just goes back to what we already covered around trademark and making sure that you are the first to present your brand in these new spaces, and keeping in mind that just like in the real world, people might rework your label and rework your logo and sell it kind of as an artistic version. What's that line, and how do you make sure, again, to get out in front of it? And so no real question, just it's exciting to see all the different spaces that this moves into as the metaverse evolves. And we'll see what happens. But yeah, Mike, I don't know if you have anything else.
I do have one further point to make, and it's
Yeah.
a really important point for brands and even for consumers. Ownership is a tricky issue in the metaverse. It's tricky. In the physical world, if I own an automobile, I can go out in my driveway and I can touch that automobile. I know I have the title to the automobile. I can like pick up the title. It's a piece of paper. I can look at it, keep it in my safe deposit box. There's no question about what I own. The same would be true for your home or what have you. But when you're in a metaverse context, ownership gets tricky because there are different layers at which ownership can go one way or the other. Perfect example, going back to the minting of an NFT. So it's computer code. How do you get that NFT? What does it require? Well, it requires, unless you're a coder yourself or a software engineer, it requires for you to engage potentially third-party resources to write that code, right? Well, under existing copyright laws, guess what's protected by copyright? Computer software. So if I'm writing code, I'm the person writing the code, presumably I own it under the copyright laws, just as if I wrote a book and I put pen to paper. Once that code in the book is in tangible form, the individual who wrote it, painted it, etc., owns it. So when you're a brand and then you're engaging external technical resources, or even within your company, you have to make sure that if the technical resource, your IT department, your engineers are in-house, that their employment agreements have clauses which any IP that they develop is owned by the company. If you're engaging an outside tech company to write your code, you need to make sure that your agreement with them clearly spells out that you own whatever they develop and they don't own it. The other thing that you need to do as a brand or company is, after you get past the step of minting the NFT, now you want to sell it, right? So you should have terms and conditions on your website or in your contracts or what have you that clearly spell out for the consumer what is owned. And that generally would be, the consumer does not own the underlying physical object that's represented by the NFT, that they only own the NFT, the digital collectible, and that's it.
That's so interesting too, when we think about this trend with phygital, so the physical digital being paired in an NFT. So saying that you own this NFT, maybe this, correct me if I'm confusing, but like once you launch the NFT, let's say it's to claim this physical good, or you get access to something limited edition. So this NFT almost grants you access to something. Does that change like the flavor or the like shape of that type of contract, or what you're mentioning around writing the code and claiming the physical good? So when it comes to ownership, do you have to even go a layer deeper in considering how the NFT interacts with the physical world? If that makes sense.
So on the coding question, that question doesn't change.
Yeah.
You always have to make sure that the individual company, whomever that codes the NFT, does not have ownership rights in the code. With respect to an NFT having some more tangible connection to a physical item. That would be what we have in the StockX case, right?
Right.
Because the consumer has purchased the physical good and has the NFT as proof of that transaction.
Right.
Well, I think in that scenario, ownership is actually more straightforward because it's more akin to the physical world. So if I go to a department store and I buy a dress, I get the physical dress, I own the physical dress, and they give me a receipt, a paper or electronic receipt for my purchase.
Mm-hmm.
So if you're going to own the NFT and the corresponding physical item, the NFT will act like a receipt and you'll own the physical item. So it's much more straightforward. Where it gets tricky is spelling in this scenario that I mentioned, where you don't have any ownership interest in the physical item. You need to be very clear that the consumer has no ownership interest in that. And a related point is, let's say you have an NFT platform.
Right.
I'm a brand. I decide to create my own platform to sell the NFTs and what have you, or to use the NFT or whatever it is, or virtual piece of virtual fashion, doesn't matter. So if you're telling the consumer that they own the NFT, they have ownership rights, and NFTs cannot exist without the blockchain. The blockchain can exist without NFTs, but NFTs cannot exist without the blockchain or a blockchain equivalent. So what happens when you pull that platform away? When you take, this is just something I'm pulling out of thin air. It's not actually what's going on. But let's say at some point the government regulates the blockchain to the point where it's just not usable and your NFT has no value, right? Well, go back in time to the agreement you had when you sold that NFT to a consumer, like you own this is something you own, you have rights in it, blah, blah, blah. But then when you take the platform that's needed to support that NFT existence away, what does the consumer own? So you have to make sure in your contractual agreements that you're anticipating this, right? So that you don't get caught in a situation where you're being accused of fraudulent activities. You made a representation to a consumer that's not actually fully accurate, etc. So that would be something else that brands and companies need to think about.
That's so interesting because it reminds me of, as we were witnessing the scale of NFTs like really exploding over the last 2 years, one of the primary questions was, okay, I bought this, valuable NFT and it lives on this platform like an OpenSea, for example. What if they fail? And then what happens? Do I still own it? Can I sell it somewhere else? And so it was been interesting to have that in the back of people's minds as they're trading value and trying to understand what does it mean to own an NFT. So that was a great run through of how to think through it.
And I cannot emphasize this enough, because this is a new horizon we're embarking upon in the metaverse. And even lawyers like myself, as I alluded to earlier in this conversation, we don't know how the courts are going to settle all the laws around the metaverse, physical world law in the metaverse. So the smart thing to do for brands is not to cut corners, consult with legal counsel, because I can promise you that it will be much less expensive to do it right, or as right as you can get it from the very beginning, than to have your legal team, lawyers, etc., pull you out of the ditch.
Right. I think that's a great way to end this for sure. We're experiencing that with the clients that we're working on, is there's quite a bit of legal due diligence done at the beginning, and the legal teams are getting involved actually quite early in the process. I'm sure a lot earlier than they were on typical marketing programs. So I think that's perfect perspective. Gina, thank you very much for your time today and all the insights. It was really interesting to hear, and I'm sure it's going to be very helpful to people listening.
Well, thank you for having me. It's been my total pleasure.
Wonderful. Thanks. We'll see you next. Thanks everybody for listening. Thank you for listening to this episode of Metaverse Matters by Pebble Ventures. If you enjoyed the content, please do subscribe and rate the show. You could also connect with us on LinkedIn at pebbleventures.com or directly at mike@pebbleventures.com. If you're a brand exploring the space, or you're already testing and are looking to develop next level strategies, please do reach out. We'd welcome an introductory conversation to learn more about your goals, where you are in the process, and share our thoughts about your business. Have a great day.